Well, once again, good afternoon. Welcome back. Having dealt with the idiocy of that Gilter comment, now to have a look at something far more important, which of course is the idiocy of the state, and in particular Ghan, Fallon and Weigert in ignoring the statute that prevents the bones from being handed back, or should have done. So I've got a couple of articles. Some of them are a couple of years old, but as usual, they are very interesting and always of benefit for people who are joining the party, if you like, later. As I say, it never ceases to. Well, it doesn't amaze me. It doesn't amaze me at all that every day I'm meeting new people who say, "Oh, I've watched that. I saw that. Yeah." Are they still locked up? And the reach of making a murder cannot obviously be overstated. So anyway, here we go. Hi there, TTM fangirl, and hi JD, and yes, deja vu, exactly. Let's have a look at some articles. Let's, as I say, let's dispense with the idiocy of some of the Gilter comments, which really, I shouldn't really bother with them at all. But I like to share with you some of the stuff that comes my way. Just make sure everything's going as it should. Yeah, okay. Here we go. Article number 1. Let's do this one first. Accept all. This. Okay, I'll just have to read in between. I'm not too sure quite how to get rid of this this banner here, but never mind. Oh, there we go. Good. Okay. Wrongful convictions. What date are we talking about? We're talking about sometime in 2018. Let's go back up there. By Kelly Wynn on that's November the 8th, 2018. So just over 2 years ago. Okay, so at least we know where we're at. Wrongful convictions attorney Kathleen Zellner shot back at accusations from former Calumet County prosecutor Ken Kratz. He claimed that Kathleen's research tactics in the case of Stephen Avery, which was featured in Netflix's Making a Murder Part 2, were, quote, junk science. I think it's appalling the Wisconsin Department of Justice anointed this de facto spokesman who has a suspended law license and a history of sexting, Kathleen told Newsweek Monday. He continues to report factual inaccuracies. DOJ, can't you do better than this? According to Newsweek, Zellner and Kratz have one thing in common: their dedication to speaking on the Avery case. Although, of course, Kratz has gone deafeningly silent recently. Beyond that, they're essentially polar opposites. Oh yes. Kathleen is currently working on Steve's post-conviction appeal, and Kratz, who worked against Avery as the prosecution of his initial trial, has a suspended law license. Despite his current standing with the Wisconsin Department, Kratz continues to express his views on the Avery case, that Steve is guilty of the murder of Teresa Halbach beyond a reasonable doubt, and the jury got it right when they sentenced him to life in prison without parole. Of course, Kathleen claims Steve is innocent, and Kratz's methods of conviction were unethical and unjust. In Making a Murder, or as we call it, MAM, Part 2, Kathleen's team is seen conducting experiments for the freedom of Steve on all fronts, from ballistics to DNA testing, and even recreating parts of the crime scene with real blood. The Sweaty Prize told USA Today Network, Wisconsin, that the research Kathleen has presented is unimpressive. Quote, most legal experts in Wisconsin view Kathleen's, quote, new evidence as a joke. I'm not sure how many times she needs to be thrown out of court before she admits her promises of identifying the real killer was nothing but a desperate publicity stunt, he said on October 29th. Kathleen, however, noted Kratz was incorrect to say the courts have thrown her out. The Avery case has only been denied once by a trial court and is currently working on an appeal. And of course, that trial court has looked at the case now 3 times and done absolutely nothing. And I think she too will get, as Lucius Malfoy once said, I'm sure that she too will meet a sticky end. Kathleen, it's certain the case will get an evidentiary hearing based on the scientific evidence she and her team have uncovered. As soon as there was the slightest inkling that anything was wrong, that should have happened, of course. And, as she says, there's so much evidence that shows there should be a second trial, she said. Although whether the state would want to go to a second trial, I very much doubt. Avery should be retried, and if the prosecution is so convinced that they've got such a strong case, let them try it against me and my experts. Let them convince a jury that they've got proof beyond reasonable doubt. With all the evidence out there, the blood, the paint on the bullet, let's have a trial. What is the big fear of doing that? A little bit like, what have they got to hide? What have they got? What is their big fear? I think we know what their big fear is. And I think that's it as far as that article is concerned. So let's move on to the next one. Hopefully we won't have any pop-up adverts here. Let's just pop up, see if I've missed the very top of this. Here we go. To Took a while to load. February 15th of last year. Steve Navery's lawyer accuses Wisconsin AG's office of destroying evidence. So moving forward, of course, Kathleen Zellner says bone fragments that could have exonerated her client were given to Teresa Halbach's family in 2011 and claims that the prosecution has been lying about it ever since. Attorney Kathleen Zellner has filed a new letter with the Wisconsin Court of Appeals on behalf of her client Stephen Avery, accusing the Attorney General's office of trying to deceive her and the court about the status of key forensic evidence in this case. Zellner's letter, submitted on February the 13th, 2019, is actually her second letter to the court in as many days. Both letters supplement a January 24th motion that accused prosecutors of violating state law and Avery's constitutional rights by destroying evidence. Zellner tells Rolling Stone that she has since learned that a key piece of evidence, suspected human pelvic bone fragments, which could exonerate her client, may have been destroyed as well. And she says prosecutors are obstructing her efforts to find out. According to a newly discovered police report and updated evidence control ledgers on September the 20th, 2011, human bone fragments recovered during the investigation were removed from the Calumet County Sheriff's Department Evidence Control Unit. They were transferred to a local funeral home, which then returned the bones to the family of murder victim Teresa Halbach. According to an affidavit from Steve's former appellate attorney, Suzanne Hagopian, the state never informed defense counsel of its intention to effectively destroy key case evidence by giving it to the victim's family. Wisconsin law requires law enforcement to preserve any biological material and physical evidence until the convicted defendant has been discharged from prison. Steve is serving a life sentence without the possibility of parole, and the Wisconsin statute protects his right to certain evidence that may reasonably be used to incriminate or exculpate any person in Teresa's murder. Calumet County Sheriff's Department Deputy Jeremy Hawkins states in the 2011 police report that Sergeant Investigator Mark Weigert and attorneys Thomas Fallon and Norm Ghan were involved in removing the bones from evidence control. Weigert was a lead investigator in the case while Fallon and Ghan were on the trial prosecution team. Fallon is now an assistant attorney general, and he and Ghan continue to represent the case on behalf of the state of Wisconsin as Steve appeals his conviction. Rolling Stone sent Fallon and Ghan a detailed request for comment on the claims outlined in Zellner's court filings. A spokesperson for the Attorney General's office replied to say that they cannot comment on ongoing litigation. The September 20th, 2011 police report, which Zellner says she received in December from an anonymous third party who, if my facts are correct, I believe that's a young lady in Australia, Carol, has exposed a lot more than just a violation of state law. A thorough assessment of updated evidence control ledgers and crime lab unit reports attached as exhibits to her 4 most recent court filings and reviewed by Rolling Stone, indicates that the human bones recovered during the investigation were more plentiful than had ever been conveyed to the defence, and many of the bones that were returned to the Holbach family in 2011 were collected from locations that prosecutors claimed had nothing to do with her murder. According to police and prosecutors, Steve fatally shot Teresa in his garage, dismembered and then burned her body in a pit next to his trailer. Investigators recovered charred human remains, namely bone from Ava's burn pit and a burn barrel, although of course we have no photos of these bones in the burn pit. However, there was also evidence of a second burn location just over half a mile from Steve's trailer. The Manitowoc County Quarry is about a quarter mile from what used to be a back entrance to the salvage yard. That's where investigators recovered another burn pile containing possible human pelvic bone fragments. At trial, Steve's attorneys theorised that the quarry bones were evidence that Teresa's body was burned somewhere other than the salvage yard. Prosecutor Ken Kratz, on the other hand, downplayed the possibility that they were human, telling the jury, quote, "These bones in the quarry, I'm going to take 20 seconds to talk about, because the best anyone can say is that they are possibly human." Kathleen has wanted to get her hands on the suspected human pelvic bones since November 2016, when the Wisconsin Circuit Court ordered new scientific testing on certain items of evidence. In September 2017, Assistant Attorney Fallon agreed to allow a microscopic examination of the pelvic bone fragments to determine whether they're human. For Kathleen, this examination is just the first step towards proving a long-time defence theory that Teresa was killed, dismembered and burned at another location. Now, Jerry Buting, Steve's trial lawyer, even said if her body parts are over in the quarry, then Stephen Avery's innocent, because the prosecution said she never left the property. Zellner says, plus he's not going to bring the bones from the quarry and plant them in his burn pit. However, soon after the parties agreed to examine the bones, the Circuit Court issued a seemingly hasty decision denying Steve's petition for post-conviction relief, despite the fact that several court-ordered tests were still pending. Examining the bones has been put on hold, pending a ruling by the Court of Appeals. Late last year, Kathleen learned about a new type of advanced DNA testing that had been used to identify victims in the California wildfires, whose remains were significantly destroyed. She began combing through the crime lab reports and evidence control ledgers in order to compile a master index of all the bones that had been collected during the Teresa murder investigation, and realized that 3 burn piles had been found around the Manitowoc County Quarry, and all of them contained bones described as human or suspected human. On December 14th, 2018, Kathleen filed a motion for DNA testing on all the human and suspected human quarry bones, including the pelvic bone fragments. The Court of Appeals denied her request to remand the case, but indicated that testing was something she could request in the future after they had ruled on issues already under appeal. Kathleen's December motion and its disclosure about the 3 piles of quarry bones caught the eye of a third party, who provided Kathleen with a copy of the previously undisclosed 2011 CASO report. Zellner's evidence control ledgers were from 2007, so she filed a Freedom of Information Act, a FOIA request, for the most recent versions, which confirmed that all of the property numbers listed on the police report had indeed been checked out on that date. It also indicated that many of the human and suspected human bones recovered from the quarry piles had never been returned, confirming that they were among the bones that had been released to the Holbach family. It isn't just the pelvic bone. There's about 10 bones that were recovered from the quarry, Kathleen tells Rolling Stones. By giving them to the Holbach family, they have just confirmed they believe those bones are human. It's a very sneaky way to get evidence destroyed. It seems very deliberate that the thinking was, we need to get rid of those bones, but we can't just go in and cremate them ourselves. At first, Kathleen believed that the pelvic bones fragments must still be in evidence, since Fallon and Ghan had agreed to the microscopic examination. Then I started thinking, why didn't the state tell the court in December when I asked to test these bones? Quote, there are no bones to test, Zellner says. I start worrying that the pelvic bones had been given back too, even though that's what we kept talking about testing, and they were telling me they had it. But I can't trust them about anything because they haven't disclosed to the court or anyone that they gave all the bones to the Holbachs. Upon closer review of the evidence control ledgers, Kathleen found a notation indicating that the pelvic bone fragments had been deemed only human, and they too had been removed from evidence control in 2011 and were never returned. Kathleen has submitted to the court, and Rolling Stones has reviewed more than a dozen exhibits which corroborate these claims. After filing her first letter to the Court of Appeals on February 11th, Kathleen sent multiple emails to Fallon requesting an update on the status of the pelvic bones, asking outright if they'd been released to the Holbach family as well. On the morning of February the 13th, she received a voicemail from attorney Mark Williams, who is co-counsel on the Avery case alongside Fallon and Ghan. The voicemail and transcript were filed along with her February 13th letter and provided to Rolling Stone and can be heard here. Williams appears to be under the mistaken impression that he's leaving a message to Fallon. He says, "Hi Tom, this is Mark Williams. I'll send you an email later today, but I don't think we should do anything or respond to her, Lady Zellner, at or until tomorrow, when we look into the bag and see exactly the pelvic bones are in there or not. So I would not respond until we look into the bag tomorrow morning, and then we can talk about it before we send a response. Thanks a lot. Bye." Now, obviously, there's quite a lot of speculation as to how did Mark Williams supposedly inadvertently get in touch with Kathleen Zellner. Of course, the bottom line is that the message has done little to dissuade Kathleen's fears that the pelvic bone fragments have been destroyed as well. At the very least, she tells Rolling Stones, the message strongly suggests that prosecutors aren't certain that the bones are still in evidence. This is another first for me, Zellner tells Rolling Stone. Many times I have felt that certain prosecutors were obstructing my efforts, but this is the first time a prosecutor has actually called my phone and left a message confirming that fact. It's really very thoughtful of them. Obviously, Kathleen also believes that by destroying the bones, the state not only violated their own statute, they've also denied Avery his constitutional right to due process according to Arizona versus Youngblood. The 1988 Supreme Court decision requires proof that the state acted in bad faith by destroying or losing evidence. It's a very difficult standard to meet, but Kathleen believes this case would qualify, and I have no doubt that it will. Her January 24th motion asks for the case be remanded back to the Circuit Court so it can address these claims, both of which would all but require the court to overturn Avery's conviction. That is, from Steve's point of view, the remedy in this situation, I believe, to simply say we are overturning the conviction. They've been lying all this time about it, and they've been lying to the court, Zellner continues. This whole concealment of what happened to the bones is really a way bigger issue than testing them even. Because if they've been destroyed, it's a violation of their state statute. I don't know if it's a felony, but it's up there. And that's what the court is grappling with. I don't think there's any doubt that it's a felony. I don't think there's any doubt whatsoever. A couple more quick articles about preservation that I found. Law enforcement officers and prosecutors have a duty to preserve certain kinds of evidence, learn what they have to keep and what happens when they don't keep it. The government has a duty to preserve certain types of evidence it collects during criminal investigations and prosecutions. This duty exists in order to protect a defendant's right to due process and a fair trial under the 6th and 14th Amendments of the US Constitution. The duty relates to the requirement that the government disclose evidence it will use against the defendant at trial, as well as any evidence that is favourable to the defendant. The duty to preserve evidence begins once any state agency or actor has gathered and taken possession of evidence as part of a criminal investigation. Law enforcement doesn't need to preserve all evidence it collects. The duty to preserve extends only to evidence that might be expected to play a significant role in the suspect's defense. Material and exculpatory evidence. Material evidence is important evidence that's directly relevant to an issue in the defendant's case. Exculpatory evidence is evidence favourable to the defendant in that it clears or tends to clear him of guilt. Alibi evidence, exactly what evidence is material and exculpatory depends upon the circumstances of the case, but alibi evidence is virtually always material and exculpatory. It includes witness statements that place the defendant somewhere other than the scene of the crime and forensic evidence like DNA that tends to show that the defendant couldn't have committed the crime. In many cases, law enforcement doesn't have obvious alibi evidence, but it does have other kinds of material and exculpatory evidence. An example is evidence that impeaches the prosecution's witnesses or otherwise weakens its case. Such evidence may include crime scene evidence. Most jurisdictions have local and state rules about the collection and preservation of evidence at the crime scene, such as the murder weapon, blood samples, and photographs. Photographs of the scene. Well, we've not got any of them. Tape recordings and videotapes. The police usually aren't required to tape record statements of the defendant or witnesses. However, if they do make audio or video recordings of statements, they have to preserve them. Investigative notes. Most states require officers and investigators to preserve investigative notes only if they made them during an interrogation by the defendant. But if these notes contain certain exculpatory information, that information must be conveyed to the defense. Emergency call recordings. Law enforcement typically must preserve and disclose 911 recordings or transcripts of the calls to the defendant, who has to preserve evidence. While the police typically collect most evidence used in a criminal case, they aren't the only government actors who have to preserve evidence. The duty also extends to local, county, and state investigative agencies. These include not just detectives and investigators, but also administrative, clerical, and forensic staff. Prosecutors. The attorneys prosecuting the case have an obvious duty to preserve evidence, as do people acting under prosecutorial authority, for example, investigators or experts retained by the prosecutor's office, the Attorney General. In most states and in most cases, the duty to preserve evidence remains even after a defendant has been convicted. Therefore, the duty applies to a state's Attorney General's office, which typically handles appeals and post-conviction matters. The duty to preserve evidence doesn't extend to private people or agencies unless they have a formal relationship with a law enforcement agency. Thus, if a private DNA lab is hired by the prosecutor to examine blood samples collected from a crime scene, that lab must protect and preserve the evidence and the results of any testing it conducts on the evidence. What happens if evidence is lost or destroyed? Defendants have the burden of proving that the state violated its duty to preserve evidence and that violation compromised the rights of due process and a fair trial. Courts won't do anything about an alleged violation unless the defendant proves that the evidence in question was material and potentially exculpatory and that the government acted in bad faith. In practice, it's very difficult to prove these points. But in reality, Kathleen Zellner is doing exactly that. And the state really have shot themselves in the foot when they handed back those bones. They never thought for one moment how important they would be. In order to prove that the evidence was material, the defendant must establish that law enforcement officers had reason to believe the evidence was exculpatory before they destroyed it. Well, the fact that they've handed it to the holdbacks, that tells us a huge amount, doesn't it? The evidence can't be replaced. No, it can't, by other reasonably available evidence. Courts can sometimes infer materiality from law enforcement's actions. For example, the fact that the state normally preserves the type of evidence that it destroyed in the defendant's case may show that the evidence was material. Similarly, the government testing, using or intending to test or use the evidence provides a strong indication that it recognized the importance of that evidence. Proving bad faith. Proving bad faith is tough. It's not enough that government actors were careless or negligent with the evidence. Well, they certainly weren't that. The defendant must show willful, yes, deceitful, yes, and malicious, yes, intent. The government failing to follow standard procedures when it lost or destroyed evidence can support an inference of bad faith. An example of bad faith is an officer throwing away a fingerprint sample showing that someone other than the defendant committed the crime. Remedies. There are several possible remedies for defendants who learn during trial that the state violated the duty to preserve evidence. They can ask the court to suppress related evidence, exclude or limit testimony about the missing evidence, or dismiss the case. I think it's without date it's that serious, this is the remedy: to simply dismiss the case. If the missing evidence doesn't surface until after a conviction, overturning the conviction and obtaining a new trial on appeal are possible. I mean, obviously, you can let me know what you think is going to happen next. Don't be shy. You aren't normally shy. One more. Seeing as this is Hart and Powell in Milwaukee. Federal charges include bank and mail fraud, drug trafficking and conspiracies, gun crimes, internet sex crimes, Medicare and healthcare fraud, perjury, and obstruction of justice. I think that's definitely where we stand with the handing back of evidence. Pre-indictment. Anyway, let's carry on. Wisconsin records notices and evidence tampering crimes. In the state of Wisconsin, any manipulation or destruction of evidence and documents of public interest is considered a serious crime. As such, tampering with records or notices and destroying subpoenaed documents are prosecuted harshly. If convicted of these crimes, a defendant can face severe penalties that often include jail sentences, hard-hitting fines, and even the loss of certain rights and privileges. Penalties for tampering in convictions. A person convicted of a tampering crime may face severe penalties, although these punishments can differ depending on the specific type of crime and the circumstances of its commission. In particular, the following classifications are used for tampering-related allegations. Tampering with public records is a Class H felony, but tampering with public notices is a misdemeanor. Destroying documents subpoenaed by the court is a Class I felony. Inducing someone else to destroy documents subpoenaed by the court is also is that Class 1 or Class I felony? I mean, there's no doubt about how serious this is when Ghan was actually during the Stephen Avery Commission that they came up with this statute about the preservation of evidence and even down to the nitty gritty of what should be preserved, what can be considered as being important and has to be kept. And the fact that they got together knowing full well what they were doing, there can be no suggestion that they somehow just simply didn't realise, that they were ignorant, that they'd done it by mistake. Felony grade convictions may come with mandatory prison sentences and several thousands of dollars worth of fine. These convictions can also result in the permanent loss of basic rights and privileges, as well as devastating collateral consequences at home and at work, such as the loss of one's job. Well, I know that we're dealing with people who are semi-retired, but it's not too late to lock them up, and I hope they do get locked up. Misdemeanor grade convictions, although not quite as catastrophic, can still lead to stressful penalties, including jail sentencing and heavy criminal fines. So, Tom Fallon, Norm Ghan, Mark Weigert, this next bit will be of particular interest to you. Contact us if you've been arrested on a tampering or document destruction accusation. We may be able to help you fight for your freedom or reduced sentences. To discuss your full range of options as a defendant facing these troublesome charges, contact an attorney from Hart Powell today by calling 414-271-9595. Okay, Tom and Norm, there you go. just doing my bit to try and help. Right, okay, I've just had another voicemail. I actually nipped out to take my car in, not quite the same as Pete Dassey with his wheel bearing, but to get a couple of winter tyres fitted on the front of the car. So it looks very much as if they're phoning me to tell me that it's ready to pick up. So I will go and attend to that straight away. Thank you all for joining me once again. Yeah, I mean, I suppose I can see why the state have got their knickers in such a twist over this. They really have shot themselves seriously in the foot. There's really not much wriggle room in this as far as remedies are concerned. It was blatant. It was bad faith. It was obstruction of justice. It was all of those things that we've looked at, and I don't think there's any doubt whatsoever that Ghan and Fallon and Weigert will be facing prison sentences. They'll be swapping places soon with Steve and Brendan. Anyway, I'm going to say cheerio because I better go and check out, see what this voice message is. As I say, thank you for tuning in. We'll catch you all